time does not allow to go into the historical development of the rules of the law of the sea, going back to Hugo Grotius and his De Mare Liberum of 1648, or earlier still, the Rhodian Code of the 3rd century BC. Nor is it possible to deal with the earlier attempts at codification by the United Nations, which were superseded by the much more ambitious undertaking of the 3rd United Nations Conference on the Law of the Sea, 1973-1982. The resultant convention, this veritable constitution of the oceans, consisting of 320 articles and 9 annexes, was signed in Montego Bay, Jamaica on December 10, 1982, and regulated a multitude of issues. These included old traditional concepts such as the territorial sea and freedom of navigation, and new concepts such as the exclusive economic zone, EEZ for short, the regime of the deep seabed, and archipelagic waters. Small delegations, such as ours, while not totally neglecting issues marginal to their country's interests, such as environmental protection and scientific research, archipelagic waters, passage through straits, they, of necessity, had to concentrate on those issues which were of direct significance to us. In the case of Cyprus, in addition to strongly supporting the adoption of the 12-mile territorial sea, Article 3 of the Convention, Cyprus had already in 1964 proclaimed a 12-mile territorial sea zone, and that enclosed and semi-enclosed seas, such as the Mediterranean, were regulated by the same basic rules as those applicable to open seas and oceans, as is the Pacific or the Atlantic, for instance, subject to an acceptable duty to cooperate with other riparian states. This was done in Articles 122 and 123. We also concentrated on items such as the protection of archaeological objects found in the seabed, Articles 149 and 303. And apart from these items, we concentrated on certain key issues of primary importance to Cyprus. These were, firstly, the regime of islands and their undiminished entitlement to the zones of maritime jurisdiction, that is to say, territorial sea, exclusive economic zone, continental shelf, and contiguous zone. This was dealt with in Article 121. Secondly, the question of the delimitation of these zones of maritime jurisdiction between states, the coasts of which are opposite or adjacent to each other. And these were dealt with in Articles 15, 74, and 83. And thirdly, the question of settlement of disputes in Part 5 of the 15 of the Convention. I do not think I need to elaborate on why these issues are of primary concern to Cyprus. All you need to do is to have a look at the map of the Eastern Mediterranean to realize why. And for your convenience, we have a map. The one, actually both are relevant. The one on the left has the blocks which I shall come to later, and the one on the right has the territorial waters delineation and the median line which hopefully at some point will be agreed upon, but so far has been agreed only in relation to Egypt and to Lebanon. And it's marked on the map on the left. Perhaps you need to go closer to see the blue line. Cyprus is, of course, an island state, as for instance is Malta in the Mediterranean, and Jamaica in the Caribbean, both semi-enclosed seas. Despite efforts made by some states, notably by Turkey in the preparatory committee, the one which preceded the conference and which took place mostly in Geneva from 1970 to 1973, and where I also participated. And in the early stages of the conference, the effort, as I said, was made to differentiate between island states and other islands. However, this effort faced coordinated opposition and did not succeed. Consequently, all islands, including the Greek islands in the Aegean, other than uninhabited rocks, are governed by the same basic rule as had been our objective. Our objective was fully met on this question of safeguarding the rights of islands. Cyprus, an island surrounded in three directions, north, east, and south, by continental states, and to the west by the Greek islands of Crete, Rhodes, and Carpathos, and indeed Castellorizo, although that's a rather special case, in no direction reaching 400 miles, 200 from each side. In fact, nowhere in the Mediterranean can you have the full entitlement to 200 miles from each side. Therefore, it is self-evident that the application of the median or equidistant line as the basic rule for the limitation is of primary importance, especially when it comes to the EEZ and indeed the continental shelf, which are coextensive in the ordinary situation. Additionally to establishing that an island has no less entitlement to the zones of maritime jurisdiction than continental territories, and also that the median line is the starting point and basic rule for the limitation, it is essential, especially for small and militarily weak states, such as Cyprus, that there be in place an effective system of compulsory settlement of disputes, ensuring that the rights of all states are equally protected. Our position on this point was spelled out in a statement which we made in the plenary of the conference in 1976, and which was motivated both by reason of our attachment to the general principle of equal justice under the law, and by national self-interest as a small and militarily weak state which needs the protection of the law, impartially and effectively administered, in order to safeguard its legitimate interests under the Convention. In other words, we were firmly for the rule of law and against the law of the jungle, a point to which I shall revert in light of the current situation regarding the EEZ. Evidently, time does not allow to develop the arguments used and the alliances and tactics used or to describe in any detail as to how these basic positions fared in the course of the conference. If I may say so in all modesty, the Cyprus delegation was at different stages the champion and spokesman of the islands group and the median line group. The UN publications on the legislative history of the regime of islands, delimitation and dispute settlement provide ample material for anyone wishing to pursue it. May I also refer you to a 28-page lecture which I had occasion to give at the Rhodes Maritime Academy for Maritime Law and Policy in July 2004, and a published version of it in a Norwegian Oslo University publication of 2006 for additional material. I'm afraid we have to be, I have to refer you to these other papers since we cannot really get into the details of these aspects. Could we get perhaps in due course the lecture copied or the...
Absolutely. Actually, I can email it to everybody participating.
It's a little too long. I wouldn't want to... anyway, it's optional as to who wants to read it. For the purposes of today's presentation, suffice it to say that as far as the status of islands is concerned, our position is fully safeguarded through Article 121, subject to the qualified exception of rocks. As far as the median line is concerned, it continues to be the general rule as far as the territorial sea and the contiguous zone are concerned, but less clear as far as the EEZ and the continental shelf are concerned under Articles 74 and 83, which were the object of long and strenuous negotiations for many, many years, and they ended up in some kind of compromise with constructive ambiguities, if I may say so. However, in subsequent years, the situation on this point, the limitation of the EEZ and the continental shelf, which was vague in the conference, in subsequent years, the situation was clarified in the right direction through judicial interpretation in such cases before the International Court of Justice and arbitral tribunals as Libya, Malta, Norway, Denmark, the Van Mayen case, Qatar, Bahrain, Cameroon, Nigeria, the Bankasi Peninsula case, Yemen, Eritrea, Barbados, Trinidad and Tobago, Guyana, Suriname, and most recently, Romania and Ukraine in the International Court of Justice. As far as compulsory third-party settlement is concerned, the relevant part 15 of the Convention represented a significant advance from previous UN codification conferences, but the disputes relating to sea boundary delimitations was made subject to an optional exception as an unavoidable concession to political realities. While in subsequent years many states have, by agreement, referred their delimitation disputes to the ICJ or to Annex 7 arbitral tribunals by mutual consent, some of these cases are already cited, realistically speaking, it is unlikely that the situation being faced by Cyprus with Turkey in the EEZ will lend itself to such a settlement. And of course, may I point out that Turkey is a non-party to the 1982 Convention for reasons I shall come back to. Now, since the topic of today refers to current issues of the law of the sea, it may be of interest to you if I cite 2 or 3 issues which currently receive much attention. One such quote-unquote hot issue, if you excuse the pun, is the Arctic, which is thawing as a result of global warming and the extension of the continental shelf by the riparian states, the riparian to the Arctic, which are 5: the Russian Federation, Canada, Norway, the United States through Alaska, and Denmark through Greenland. Of course, Greenland's status may change before too long, but for the time being, it is a Danish claim. This is a matter where big stakes are involved, since it is estimated that 20 to 25% of the world resources of oil and gas are located in the Arctic seabed and may be exploitable in the near future. The allocation of claims to the continental shelf beyond national jurisdiction, up to 350 miles, is the responsibility of one of the main bodies established by UNCLOS III, and this is the Committee on the Outer Limits of the Continental Shelf. And this applies globally, not just for the Arctic. So that's a new chapter of exploration and extension of jurisdiction, which is very much in the news and in the uppermost of a lot of people's interests. Now, for this and related issue of the revival of interest for commercially exploitable minerals in the seabed, in deep seabed, much is currently written, and some of you may have seen, for instance, the very recent 16 May 2009 issue of The Economist for interesting factors, maps, and figures on these current issues. I think I have it here. Yes, it's this issue of The Economist, and it has a lot of material on these two subjects. Now, another such issue which is receiving much attention lately is that of piracy at sea, especially off the coast of Somalia, near the Gulf of Aden. Many nations, including those of the EU, deployed warships in the area under Security Council enabling resolutions, and in coordination with the IMO, the Intergovernmental Maritime Organization, in order to combat this phenomenon. While pirates can be prosecuted under the long-standing principle that they are hostes humani generis, enemies of the human race, the subject is not free of legal complications. In fact, I saw in the Philadelphians last Sunday a big piece whereby Somalis were complaining that they were in fact defending their fisheries from outside invaders, and so they were really in self-defense and not carrying out piracy. It's a point of view. Now, returning now closer to home, after this brief diversion, let me tell you that in my 2004 Rhodes lecture, to which I referred you, there was a postscript of 4 pages focusing on some developments relative to Cyprus. Developments as of 2004. These were grouped under 4 headings. One, the Cyprus-Egypt EEZ delimitation agreement, signed in February 2003 and ratified in March 2004. To this should be added the subsequent Cyprus-Lebanon EEZ delimitation agreement of 2007 in the same terms, based on the median line and including a paragraph, a provision for arbitration regarding any disputes arising from it. I understand that a supplementary agreement was reached recently for joint exploitation of resources which may be found straddling the line of the limitation, but that I'm not quite sure how the matter stands. I wonder if there was anybody here who would be more knowledgeable on that. Mr. Cassinis was supposed to be here.
Yes, I'm here.
Oh, good. Good. So perhaps you might. Very good. Thank you. Secondly, recent Cyprus legislation proclaiming EEZ and contiguous zone. This was done in April 2004. And the person who had takes a lot of credit, I think, should take a lot of credit for this is Ambassador Sofianos, Michalis Sofianos, who took the initiative on that. I'm sure Mr. Cassinis too, but I happen to know Mr. Stavronas. Unfortunately, he couldn't be here because he was assigned to a different function this afternoon by the ministry. Thirdly, the position regarding the sovereign British areas, SBAs, as related to the law of the sea. And four, relevant provisions in the UN plan, the Annan 5 plan on a Cyprus settlement. Since we have a long way to go this afternoon, I will not tire you by going into these headings, but will be glad to make the material available, and perhaps some of you, more knowledgeable than I am on recent and current developments, as I said, Mr. Cassinis, can supplement what. Let me now turn to the current issue of oil and gas exploration by the Republic of Cyprus in its EEZ and Turkey's behavior in this regard. For the past few years, periodically, reports appear in the Cyprus press, sometimes under sensational headlines, accompanied by maps and pictures of oil platforms, on the oil and natural gas wealth of the region. It is said that the Eastern Mediterranean basin contains some $400 billion worth of oil and natural gas, that much of it lies in the area south of Cyprus, between Cyprus and Egypt, or Cyprus and Israel, Gaza, and Lebanon, within the Cyprus EEZ. Some such press reports have mentioned that Cyprus will become the new El Dorado. We shall assume the status of sheikhs and emirs with more money than we would know what to do with, and anticipate that Cyprus will join OPEC. No doubt such talk includes an element of hyperbole. There are indeed indications that some oil deposits and most probably considerable quantities of natural gas do lie in the seabed in areas to the south, east, and west of Cyprus. Foreign oil companies, including Noble and Shell, have discovered substantial natural gas deposits off the coast of Egypt and of Israel and of Gaza. And chances are that there exist also in the adjacent Cyprus EEZ, as preliminary research has confirmed. But whether these deposits are in such a quantity and quality as to be commercially exploitable, and whether the depth at which they are found makes exploitation difficult and expensive, remains to be seen. I say this in order to put the matter in perspective, but I do not claim any scientific special expertise on such matters. And again, I hope that Mr. Cassinis will shed some more authoritative light on this aspect of the issue. My own impression is that the Cyprus government, particularly successive ministers of commerce, beginning with Mr. Nikos Ronaldis, whose tenacity resulted in the signature of the Egypt-Cyprus agreement in the week between the change of presidents in 2003, by his going to Egypt so as not to let it slip, and subsequent ministers of commerce, including the present one, with the valuable help of the head of the ministry's energy section, have taken appropriate steps through the conclusion of the limitation agreements, notably with Egypt and Lebanon, as I said, so far, and through dividing of the EEZ area over which Cyprus has jurisdiction and sovereign rights into blocks for allocation to oil exploration companies under appropriate procedures, for us to have a cautiously optimistic expectation. In fact, the map on the left shows the blocks that I referred to. Legally, the Republic of Cyprus has sovereign rights over the whole of Cyprus, EEZ, but under present circumstances, where Turkey occupies 37% of the land and considerably more of the coasts of the island, it is prudent not to push this point, at least for now. These prospects are, however, threatened by the fact that Turkey and the Turkish Cypriots are raising political and legal obstacles which in turn may discourage major oil companies from undertaking commitments in areas of the legal status of which is disputed. The Turkish Cypriot argument that, and I quote, the Greek Cypriots are not to proceed on their own and the Turkish Cypriots are co-owners and they have to participate in the prospective profits, unquote, legally speaking, has no leg to stand on. I don't need to go into the details as to the legal status of the quote-unquote TRNC. Resolutions 541 and 550 are quite clear on the subject. The ownership of such deposits, as may be found in the Republic's EEZ, is of the Republic of Cyprus, which has a government recognized by all states in the world as such, except for Turkey. Indeed, under the Ankara Protocol since 2005, if I'm not mistaken, 2005 or 2006, Turkey has a conventional obligation to recognize the Republic of Cyprus and to open its ports, airports, and airspace to it, an obligation which Turkey has so far failed to meet. So it is not a matter of any national group within Cyprus, be it the Greek Cypriots or the Turkish Cypriots or indeed the Armenians, the Maronites or the Latins, but the state of Cyprus and its government, which is entitled to the living and non-living resources of the Cyprus EEZ. Incidentally, and I mentioned this as an indication, under the Treaty of Establishment of 1960, Appendix O 310, it was specified that should minerals be found in the soil of the sovereign base areas, the benefit should accrue to the Republic of Cyprus. Now, if and when, hopefully when, there is a solution to the Cyprus problem, the people of the reunited Cyprus will, through such governmental structure as will have been agreed upon, own the wealth of the Cyprus EEZ. I am aware that there has been a suggestion that a portion of the oil and gas wealth to be found, if it is found, and if it is commercially exploitable, be deposited in an account to the benefit of the Turkish Cypriots upon a political solution being achieved. However, this, if it is practicable, would be a political, pragmatic accommodation, not a legal obligation, and here we are discussing the legal position. A more substantial obstacle lies in Turkey's claim to a segment of the EEZ under the Cyprus-Egypt delimitation agreement, west, if I understand correctly, please correct me, Mr. Kassinis, west of the 32nd parallel. I see the figure of 32, 16, 18, whatever this may be. And you can see it, I think, in, where is this paper that's been distributed? It's I think it's the red line to the west of Cyprus, which clashes with the Cyprus EEZ under the Egyptian Cyprus agreement. Turkey also claims not to recognize the Cyprus-Egypt agreement. They have declared so. Now, apparently, this claim is based on the theory put forward by Turkey during the Law of the Sea conference, originally to the continental shelf and EEZ of the Aegean, purporting to divide it between the continental shores of Greece and of Turkey. this novel and unfounded and arbitrary, if I may say, theory, based on the assumption that islands have no continental shelf of their own. The way it was put was that islands are sitting on the continental shelf of continental states. And of course, it so happens that etymologically, continental shelf is not insular shelf, but as we have already said, under the Article 121, it was established that islands have continental shelf of their own the same way as continental territories. There is a bit of an etymological contradiction because islands should have insular shelves, but it's called continental shelf nevertheless. Now, as I said, this theory received no support, and the conference, since we have already seen, by adopting Article 121, accepted that all islands in the Aegean have their own continental shelf, so no more was made of this theory. Turkey's subsequent attempt to argue that in enclosed and semi-enclosed seas, special rules should apply, having lost the argument about the median line and the islands, they said, this applies to open seas. When it comes to enclosed or semi-enclosed seas, as the Mediterranean is, special rules should apply. Well, this was rejected also after considerable argument, and the result is Articles 122 and 123 on enclosed and semi-enclosed seas, which were not satisfactory to Turkey. As a result of losing on these and other issues, including the fact that Turkey insisted in having the right to make reservations on particular articles, which was denied, because if that had been allowed, then the whole convention would be in danger, because everybody would put forward reservations to particular articles which they didn't like, so it was excluded. So as a result of the fact that Turkey was not satisfied by several provisions, including on islands, including on median line, including on semi-enclosed seas, and the fact that they couldn't make reservations, Turkey did not sign or ratify the Law of the Sea Convention in Montego Bay. And to this date, that's significant, to this date, Turkey is the only country in the world to vote against the annual Law of the Sea resolution in the UN General Assembly. Turkey did so most recently in December 2008, as she did in all previous years. A matter which, if I may, in my opinion, if I may say, should have been appropriately raised and highlighted by Cyprus at the General Assembly, the more so since the incident whereby Turkey had proceeded with threats against Cyprus authorized vessels to explore in the EEZ occurred only 2 weeks earlier, and a fact which was duly protested to the Security Council, the same Security Council, incidentally, to which Turkey has been elected as a non-permanent member by 151 votes, and of which is president currently, without Cyprus doing very much to remind people that Cyprus was occupied for 35 years, and Security Council resolutions calling for the withdrawal of the troops went unheeded, but that's another matter. So coming back to the Law of the Sea, Turkey, a non-party to the 1982 convention, asserts that the EEZ extends halfway between the south coast of Anatolia to Egypt's coast in the Mediterranean, encroaching on Cyprus's EEZ as agreed with Egypt, in a valid agreement on the basis of the 1982 convention to which both Cyprus and Egypt are state parties. This is the situation. Turkey has notified its position to the UN Secretariat, which it was perfectly entitled to do, and which the UN Secretariat, as is the usual practice, has simply noted it. Now, Cyprus protested repeatedly to the Security Council as well as to the UN Secretariat and to the EU. If I understand correctly, and please correct me if I'm wrong, if somebody knows better, the EU recently, in a recent report on the association agreement, included a reference that Turkey should respect sovereign rights of EU members, states. That's at least one helpful expression of position by the EU. The Security Council, to which protests were made, took no action. And Turkey continues to harass and threaten Cyprus authorized vessels in the EEZ, and Cyprus reiterates its intention to continue exercising its sovereign rights in its EEZ. Now, under these circumstances, what are the appropriate steps to be taken by the Republic of Cyprus to safeguard its legitimate sovereign rights? One option would be to meet force with force, but of course, in this situation, this is a non-starter. Cyprus is 100 times smaller than Turkey and has no way of meeting the Turkish naval threat, and no realistic prospect that anyone else will do it for her. Not Greece, which has its own situation vis-à-vis Turkey, not the UK, which had a certain interpretation of its obligations as a guarantor power in '74, not the EU towards one of its member states, at least not so far, although the EU did send warships off Somalia against the pirates. And not the Sixth Fleet, unless perhaps an American vessel was involved. Another option would be to play more decisively its cards in the EU and Turkey's accession process. And perhaps one might remind ourselves of the situation of Slovenia vis-à-vis Croatia in terms of Croatia's accession process. However, I can say with assurance that Cyprus does have international law on its side. Islands have the same entitlement to the EEZ as continental territories. Cyprus has an agreement with Egypt on the basis of the Median Line. Cyprus has taken a firm position in the Law of the Sea Conference and elsewhere in favor of disputes being solved peacefully on the basis of the applicable international law rules through compulsory third-party dispute settlement. And of course, one could bring to memory the Article 2.3, paragraph 3 of the UN Charter, which imposes an obligation on all states to settle disputes peacefully. Now, why not proceed? And I ask the question, why not proceed to declare that, while it has no doubt as to its legal rights in the EEZ, Cyprus is willing to test this before the International Court of Justice, as happened in so many recent cases of the ICJ deciding the limitation disputes. For instance, as I mentioned earlier, Qatar, Bahrain, Cameroon, Nigeria, Romania, Ukraine, Norway, Denmark. It is of interest that very recently a senior EU official, Mr. Michael Lee, raised the possibility of third-party settlement if the parties in the Cyprus situation are unable to solve the issue. If we had resorted to the ICJ for an advisory opinion on the alleged and unfounded right of forcible intervention by Turkey under the Treaty of Guarantee in 1964, as suggested by Uthant, the then Secretary General, and I refer you to both to Mr. Jacovides' my deposition and to Mr. Stridiodis' book, the relevant part as to the consultations which took place on the sidelines of the adoption of the key Resolution 186 in March 4, 1964. If we had done that, as I said, as proposed, suggested by Uthant, our legal position would have been incomparably stronger in the 1974 invasion and elsewhere. If we had not resorted to the European Court of Human Rights, we would not have had the decision of Loizidou versus Turkey. If we had not resorted to the US Federal Court of Indianapolis, we would not have had the Kanakaria mosaics back in Nicosia. To mention just a few examples, the Orange case being perhaps the most recent one. A few days ago, a Cyprus newspaper report quoted a Cypriot diplomatic source that to go to third-party settlement would mean that we would cede away our legal rights. At least that's what was said. It must have been a misquotation or a misinterpretation, since to go to court to assert your rights, as at least two judges present here, former judges, would, I hope, agree, would not be to cede your rights, but would be to safeguard your rights under and that's how the rule of law operates. The difficulty with what I just urged is not that we would be ceding our rights if we declared our intention to go to court. It is that Turkey would not accept the ICJ's jurisdiction. But if we took this initiative, we would at least have the significant advantage of being perceived as relying on international law to assert our strong legitimate rights, and this by itself would be a major gain. It is sometimes said that the Cyprus problem is a political one and will not be solved through courts' decisions. I do not disagree. The Cyprus problem, if it is to be solved, will be solved politically. But it would strengthen our negotiating position enormously if the political solution was based solidly on the relevant international law rules. And let me remind you that small states have to rely on the rule of law. They cannot rely on their gunboats. So this concludes my statement. I hope I didn't make it too long. I'll be glad to answer questions, and perhaps we could have the discussion. Thank you.
Thank you very much, Andreas. I open the floor to questions. Keep them precise so that the speaker can answer. Please.
Given that Turkey hasn't signed the Lawful Sea Convention, what would the applicable law be as regards a dispute between Cyprus and Turkey in the international court? Assuming that Turkey accepts that the international court has jurisdiction, would someone fall back on customary international law, or is it the case that because many states have signed the convention, has it sort of assumed the status of generally applicable law?
I think you have answered your own question very much to the point. 156, as of last count, countries in the world are parties to the convention. I hope that the United States will not take long before doing the same. In fact, the Foreign Relations Committee, the Senate Foreign Relations Committee approved it more than once, and the administration was for it, even also the previous administration, but certainly the present one. So one can assert quite confidently that the provisions of the convention have assumed the force of customary law. Not to mention the fact that many of the provisions encompassed in the convention were customary law to start with beforehand. So it is a relevant factor. I think you're quite right to point it out. But the answer is that it is part of customary law, and the court can decide by reference to what the customary law is.
Yeah.
Gary?
Yeah. Is this Cyprus EEZ, is that established? That's internationally recognized. There's no further negotiation regarding that?
No, yes and no. If you look behind you, the blue map,
Yeah.
this is where the Cyprus line of the EEZ would be, the red would be, if it were accepted, if the median line was applied. Now, as I said, it's a relative, it's not an absolute rule that it should be the median line, it's a relative rule. It's subject to agreement among the states concerned, so as to achieve, in accordance with international law, so as to achieve an equitable result. And in the case of the agreement with Egypt, it was exactly on the median line. In fact, you can see the blue line on the left map, which is the median line. And the Egyptians have been very generous, not only correct in terms of the median line, we both supported in the conference, both Egypt and Cyprus that is, but they are also very generous in the sense of not insisting on an advantage which a big country with a big front like Egypt has, which was not the case in fixing the line between Malta and Libya some years before. So Egypt may have had an ulterior motive as well, because they wanted to establish the median line in their relations with, in fixing the line in the Red Sea between Saudi Arabia and Egypt. But irrespective of motivation, they are very generous with us, and that's the line with Egypt. Now, there was also a line with Lebanon in the agreement of 2007, which is also in blue on the left map, the map on the left. Now, for the other countries, that is to say Israel, Syria, and of course Turkey, and even Greece, there has been no agreement, but one could make a reasonable argument that the starting point of the limitation should be the median line. And that has been interpreted in a number of these cases that I quoted, that this is the correct position. In other words, they clarified what was in the Law of the Sea Convention by judicial interpretation, stressing the relevance of the median line, the equidistance line rule. So the answer to your question is that no, it has not been fixed. It should be fixed. Hopefully it will be fixed on the lines that shows on the map on the right.
Yeah, perhaps I wasn't clear, but what I'm curious to know is the part of the EEC where the Cyprus blocks are located, is that established?
Yes.
This area here on the left,
well,
that area is internationally recognized.
It is established vis-à-vis Egypt, but Turkey disputes it.
Yes.
To the extent that it clashes with its claim under the west of the 32nd parallel. And with Syria, it hasn't been agreed because of other complications to do with the Alexandretta and so on. Turkey is another story. And with Israel, there have been efforts. I don't know what stage they're in.
Well, if I may add something.
Please.
I don't believe that Egypt has been so generous, Mr. Jacovides, with us. I believe it has been fair. This is very good. It's very good for them regarding Libya dispute. So that is very crucial to them.
Point taken.
Turkey actually, they have written to the Egyptians at that time. I believe that George Yacobu was the Minister of Foreign Affairs, and they were claiming that you shouldn't sign with Cyprus, Mr. Mubarak. You should sign between Turkey and Egypt. They don't even recognize that we exist as a country, as a state. Of course, it was rejected by United Nations. So this has been clear and has been ratified and is everything with the United Nations and well accepted. Yes, these blocks which we have divided, and the size of it is very much related to the technical parameters of each block, the depth, the indications, the leads we may have, and so on. They've been recognized. It's a part of our exclusive economic zone. Now, regarding what we did with the Lebanese, it seems that everything has been clear, and they moving towards. They didn't have parliament for a long time.
Ratification.
Yes, I believe at that time the efforts of Madame Erado was very pronounced, and also with the Israelis. I think Israelis, although they haven't signed the median line convention, they do respect it. On a technical aspect, they indicate and they have shown us maps that they do exactly coincide with what we have prepared ourselves. So it seems that also they do respect that. And even the United States, through the previous ambassadors, if I could say a few statements here, that he quoted that Cyprus government, that they did everything according to international law and order. So, indicatively, what we've been doing has been claimed even by the United States that everything has been clear. So, I don't know anything else if you'd like to tell you. What about indications? We have leads, yes. Recently, here in this region here, Israelis, a company, the same company we have allocated this block, the block 12 to them, Noble, together with an Israeli company named Delek, they discovered a very huge deposit of natural gas in the order of 7 trillion standard cubic feet. It is clear from geological point of view and that's what has been stated by the chairman of Noble and other statement, that these deposits, they may extend to the Cypriot waters. Of course, the Noble company, they are progressing. They are now out of tenders for bringing a boat, making more survey in the region, in this block.
Which block is that?
Block 12 here. So we, of course, we extend our seismic survey. We did initially, back in the year 2006, 6,770 line kilometers. We did more lines recently. We finished in March, May. We made another 12,500 lines. We started with another 6, but because Turks, they've been intervening, we continue our survey. Of course, yes, they've been trespassing everywhere, here, everywhere. It's not the line you indicated, Mr. Jacovides. They've been all over. And they extend technical pressure, and they are going to extend technical pressure. In my opinion, we have to continue respecting the international law and order and don't take any account to them. And that's what we did, and that's why we completed the networking here of 12,500 line kilometers. And the international community, they do respect these blocks. And we have queries from Shell, from Mobil, from Statoil, from a lot of very, very big companies and esteemed companies asking Chevron. We sold our data to them, and I believe by this way is an indication that they respect what we've been doing. Thank you. I'm not a politician, I'm not a lawyer, by the way, I'm a petroleum engineer, so...
I'm very grateful to Mr. Cassinis for filling us in, because he knows more, and also take the occasion and welcome Dr. Makuli. I didn't mention it before. But let me come back to this. Turkey has declared that this 32nd parallel was theirs. Now, this one, they don't say it's theirs, but they say it's not ours. In other words, they say that Cyprus doesn't have a continental shelf, and Cyprus is not a state recognized by Turkey, and doesn't have a government which is recognized by Turkey, and therefore they can do anything they like anywhere they like. Turkey does. But what they claim as their own is this business of continent to continent, halfway.
Right.
Right. Okay, now that we've clarified this, I think we're in agreement.
One question?
Well, I was in Thessaloniki 2 days ago in an international convention of the Institute of Energy of Southeast Mediterranean there. And I've been asked similar questions, what about the Turks? And there they are very high officials, and also very, very, very well-recognized technocrats. Would you? You say, of course we do. Otherwise, what is the community in energy matters going to respect the networking and the pipelines they passing through Turkey? The international law and order is the most important and crucial issue that there is. International law which is well respected and organized. Otherwise there is another state. I mean, so many interests they pass through them and so on. So all these people, the technocrats, all these politicians, they do accepting it. Of course the military people, is their job not to accept it, because what they try to do is to safeguard their position and their chair they are sitting on. That's what is well accepted and understandable. But I don't believe that Turkey is going to jeopardize. What they have, the infrastructure of billions. We are talking about these new pipelines, Nabucco and the rest. We are talking about 7.6, 26 billion. Are they going to jeopardize this issue because of Cyprus? And believe you me, I believe Turkey is the biggest beneficiary in the case that Cyprus discover oil and gas, because the only way to give the gas to Europe, because I believe it should be the end customer, it should be European Union, it should go through Turkey. And of course, Why do you laugh, Mr. Andreas? It's true. That's what I mean.
I'm laughing at the irony.
It's not an irony.
No,
It's a irony.
the irony that it has to go through Turkey.
It has to go through Turkey. It's going to be through their transit pipelines. And they're going to get a fee for that. It could be also an agreement that they could get at a reduced price discussed. Cyprus is not a big country that it could accommodate for their own use all the gas, all the oil we bring it up. It's very costly to bring it up only for the Cyprus needs. And it's not viable to do so. So this is the reality regarding technocracy. You're laughing, Jim, but I think this is the way.
I agree.
To Ambassador Jacovides, regarding the, you mentioned the Part 15 for the compulsory settlement of disputes, and then you mentioned the third-party settlement. Is that a different thing, or and how is what is the procedure for the first, and what is the procedure for the second?
It's a very long chapter for the settlement of disputes, which covers all kinds of approaches. One is compulsory settlement, with the exception, unfortunately, for us, the exception of delimitation disputes. So it's really taking away a big chunk of what is compulsory jurisdiction. But it also provides for the option of Chapter 7 arbitration, which would be third-party settlement, compulsory. And it also has another arbitration under Chapter 8, Annex 8, which provides for technical disputes to be settled by arbitration. And there is also provision for compulsory conciliation, which is short of compulsory third-party settlement. So it's a very long chapter which was worked out over a period of years, and which all I said in my introductory statement was that it represented an advance from the dispute settlement chapters of other codification treaties, including, for instance, the North treaties, but it did not go far enough in terms of delimitation disputes, unfortunately.
So in case Cyprus decides to do what Mr. Lee has suggested,
it has a choice of either asking for the International Court of Justice or of Chapter 7 arbitration. In other words, you select the arbitrators. Some of these, Trinidad, Barbados, Trinidad, Tobago, Suriname, Guyana, Suriname, Eritrea, Yemen, were done through the Permanent Court of Arbitration, under the auspices of the Permanent Court of Arbitration, with judges being selected by the parties and 2 and 2 electing a 5th chairman.
would this necessitate the agreement of Turkey?
Yes.
Yes. So
Yes.
in case Turkey does
Yes.
not agree,
Yes.
then we cannot.
Yes. And of course, there is a, I mean, it depends on how we approach the matter. If we were to say, well, you know, we're not so sure about our position, so let's, it might cast some doubt on our rights. We should assert our rights
Yeah.
very strongly and without any reservation, and challenge Turkey to have third-party settlement, primarily the ICJ.
Nikos?
No, just why you didn't mention the International Law of the Sea
Tribunal.
Tribunal.
Yes.
Why?
Well, it's okay. It could be mentioned too. It's another option. And in fact, it was a new body which was set up by the conference, because at that time, the International Court of Justice was not considered to be so trustworthy from the point of view of the third world, because there had been a decision taken by one vote majority on Namibia some years back, which cast doubt on the reliability of the International Court of Justice from the point of view of the third world. So it was decided to establish a tribunal for law of the sea issues with its own judges, and of course it's based in Hamburg. However, in practice, this tribunal was set up in 1996, and for the past 12 years, it hasn't really taken off. It's no delimitation disputes were referred to it. They have only dealt with cases of release of vessels and some minor the disputes of this nature. In fact, the previous judge, who was a German, Mr. Wolfram, Professor Wolfram, he went out of his way to drum up business, as it were, for the tribunal, not very successfully. But that's one option. I mean, if
we have accepted it in the fourth options, we have accepted the four options.
Yes, there is another weakness for the tribunal, Law of the Sea Tribunal in this case, because it's a body under the convention, and Turkey is not a party to the convention. So the court, however, it is a party to the court. I mean, automatically, and the tribunal it could agree to, although I don't think it will in practice. So it's a good question, but it's in practical terms, it hasn't really taken off as a tribunal.
Well, perhaps someone can enlighten us. If this affair, this conflict, this whatever with Turkey, is to climax at some point, when would that be? What do we expect to happen then? And what is the position of the rest of the world, I'm referring to the big powers and the big blocs, concerning Turkish reactions to this? Not how Cyprus did things, but the reactions to what Cyprus did.
Well, that's a very good question, but it's not an easy one to answer. Of course, one could envisage a number of possibilities depending on how things would develop. Turkey is a member of the Security Council, thanks partly to no action on our part. So that's one relevant factor. It doesn't mean that it decides everything. It doesn't have a veto, but it makes a difference. Turkey is a candidate for the EU. Now, if it overdoes things in terms of using force or behaving all the way legally, then there might be some price to be paid for Turkey in its EU accession course. That's another one. A third possibility, if you have an American company, if you have an American company having the license to explore and that ship is interfered with, hopefully the United States Sixth Fleet will not stand idle by, hopefully. I mean, it's a number of possibilities depending on how things develop.
When will it climax?
If I may add something, Mr. Jacovides,
please.
Don't you think that already the Turks, they are doing their utmost best to interfere with all the oil companies, not to participate, not to be involved, not to apply for any blocks, and they are doing this by meetings, by letters, by interventions, by whatever. But I believe that the Ministry of Foreign Affairs till now, they are making good job and they are trying their utmost but also, and they show that we are a state well respected internationally, a member of the European Union and the rest. That's what we have. And I believe by giving one block out, a lot of other companies, that's why in the first bidding round we didn't have a lot of, although we have sold the data to 14 very big and esteemed companies, and they apply only few, and we know what they did even to Noble and to all the other companies and to even state companies. So they are going to continue to do so. They are going to exert pressure, the technical pressure. It's up to us going as rule of thumb, the international rules and order, as Mr. Jacovides mentioned before. That's what we have to do, and it's up to them to disrespect them. I suggested that even to the president when they've been intervening the other day, and they said to stop the ship and so on, the Norwegian ship, I said, let them sink it. Why don't you let them to sink it? To pronounce the Cyprus problem even more. I'm not a politician, but do you believe they are going to sink it? Do you believe tomorrow they are going to intervene on the platform brought by an American company? I don't believe.
So how far does anybody think Turkey will go with this?
Only technical pressure, I believe. I have shown to you that they've been intervening from the beginning, and instead of 6,000 light kilometers, we make 12,500 light kilometers, and they've been standing there yet watching. what they're going to do.
What about the Russians? What do the Russians say about it? What does the EU say about the way Turkey handles the affair? Not what Cyprus is doing.
Well, the EU, as I said, and please correct me if somebody knows better, in a recent association council report, there was an express paragraph saying that sovereign rights of member states of the EU should be respected. And I think it was a way of referring to. Correct me. Is there anybody else who knows?
Yes, I think that Turkey has suffered already a very heavy strike from the blocking on our part, and it was a unilateral veto that we exercised. It was during my tenure.
Right.
And it still stands, and I hope that it will not change. Blocking of opening of the energy, and I think this is already a very heavy burden for Turkey, but also for the European Union. We had a number of times EU Commission people trying to change our position, but I think that the Cyprus government is very right to insist that unless Turkey seizes these threats, we cannot change our position. So, so far, we have succeeded in blocking the opening of the energy chapter, and rightly so.
So this is something.
Very good.
The Republic of Cyprus established in, I think in 1964, the territorial waters.
Yes, 12 miles.
With a law. And later in 1974, established the continental shelf, 1974.
Yes, although
With a
I
law.
think, yes, it so happens that in 1974, during the conference, which was dealing with changing the rule, the Cyprus government, for some reason which I don't understand, being superseded. So, but since we signed and ratified the 1982 convention, that superseded. Yes.
Yes, this was my general question. If we need, because later we had the Treaty of Montego Bay, that it's very, very important in the continental shelf. If we need now to make a...
I think not, but the right person to ask would be Michalis Stavrinos, who took some very enterprising steps in 2004, establishing the EEZ, and I think the continental shelf, but that I'm not sure what the position is.
And another specific question on territorial waters. Cyprus has 81 small islands, rocks, around Cyprus. And based on the provisions of the Montego Bay Treaty, all these rocks and islands, they do not have continental shelf or exclusive economic zone because they do not have human presence and economical activity. But these small islands, they deserve and have the right of having territorial waters and
up to 12 miles. Up to 12 miles.
Up to 12 miles. So, making the delimitation of our continental, of our of our
territorial
waters.
Yes.
And these islands, these small islands, if they are included in the 12 miles, then they have this right. If it's outside, they don't have this right. So we can have changes on our territorial waters.
Yes,
my question is, did we took into consideration this aspect?
The answer is I think so. Is a clear delimitation of the territorial waters.
To the right map?
I believe so. I cannot see from here, but I think it's on the right. Yes.
Okay.
But to answer your question, which is perfectly legitimate, is that the line of demarcation is not the mainland. It's certain points fixed along the. If Cyprus had an island like Malta is consisting of two islands, that would be a different story because each would have its own territorial waters. In our case, we don't have any islands which are big enough, so they're in fact submerged, subsumed into the territorial sea. But in fixing the line, you choose the outer limit. For instance, Geronissos. Take the other outer limit of Geronissos, or the Cleves in, I suppose, I guess Andreas is a different story since it's under occupation, but let's stay with Geronissos. You fix the line from the outer end of Geronissos Island, which means another few hundred meters. It doesn't make much difference. But that's how I understand it was delimited. And I think if you want an authoritative answer, there is a cartographic service in the government which is run by Mr. Zenonos. I think he would give you a specific answer, but I believe that what I tell you is right.
We're wrapping up, so
Yes.
let's...